Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, be seated, please. All right, the first case we'll hear this morning is DA Real Estate Investment versus City of Norfolk. And Mr. Sherman, we'll hear from you.
May it please the court, Judge Niemeyer, Judge Thacker, Judge Quattlebaum, Joe Sherman on behalf of DA Real Estate Investment, LLC, and its single and sole member, Mr. Danny Fox, who traveled from his final duty station in Alaska to be with us here today after 27 years of honorable military service to the United States Navy. The private property rights are the guardian of all civil liberties. Without the right to own the church, the right to worship's worth little. Without owning the gun, the right to bear it means not much. And without the right to own your own home, the right to prevent quartering of soldiers in peacetime or unreasonable searches and seizures wouldn't mean much either. And so in this case, we've got a Fifth Amendment takings where the record bears out that it's a rather easy case. The city intentionally took the property, they physically destroyed the property, and there was no exigency, there was no urgency. The city's corporate representative, pages 530 and 533 of the record, express that they elected to take the property intentionally without an imminent need or threat of harm to the public. And so...
But with notice to appellant.
No, Your Honor, the notices don't bear out either. The record citations on the notices demonstrate that this is the constitutional corner cutting that Justice Holmes contemplated in 1922.
Did appellant not contact the Norfolk City inspector in May of 2018?
He did, from overseas, and he said that...
And why was that? Just out of the blue, or did he have notice of something that caused him to call?
My understanding is that a property manager, a local property manager, expressed that a car had hit the house, which caused some damage to the brick stairs on the exterior, and so they all got in contact, and so the city's got...
When he came home and he was working at the site, he said he was working fixing the accident. He was there 2 weeks. While he was working there in the site, these notices had been postponed. He called, telephone called, and emailed.
Right.
And said what he was going to do, and they said, send us a schedule. He never followed up.
Right, and so
Well, I'm just addressing the notice, and that's totally contrary to what you said. This was after he came back home, and he testified in detail to the fact he was working at the site for a couple of weeks.
Absolutely.
Mowing the lawn.
Sure.
Why, sure. You just answered that he was overseas when he got notice.
Well, and he did come home, and the record is exactly like you say, that there was some correspondence in May and April of 2018, and I think that none of that doesn't change the constitutional corner cutting of...
Hold it now. Let's take, the first question was whether he had notice, and you took issue with that.
I do, because I don't...
Now we know that he did have notice.
May I clarify? He didn't have actual notice that the city intended to demolish the property.
It said so right in the notice. It said explicitly, use the word demolish.
And
then they followed that was pursuant to a local ordinance.
No, Your Honor, the June 2018 is the only notice that used the word demolish, and that, by the record, was never served as the building code requires. It was never posted. No, Your Honor, it was not. The postings, the only postings in the record are
Postings that were in some of the pictures.
right.
What did they say?
That was apparently posting the 2017 letter, which didn't have the language about demolishing the property, only that he would be subject to fines and summons and criminal sanction. If Your Honors could take note of footnote 6 in the briefing at 1095 of the record, the briefing of 1086 to 1096 best explains the issue that you're talking about most, which is the notices. And it demonstrates that the letter that was posted in the corporate deposition, we went through that exercise, and the city representative agreed that the letter that is
Two things posted, at least two.
right, and neither one of them could be the letter that mentioned demolition because it had 6 paragraphs, not 7. So she couldn't tell exactly what was.
What did he do in response to the 2 notices on the door? He ignored them?
No, Your Honor, he made the repairs. The record bears out on.
He wrote a letter saying a long list of repairs he was going to do, and they said, provide us a schedule.
None of which were about the imminent threat of harm to anybody.
That isn't the issue. The question, we're talking about notice. Why don't we stick with what we're talking about?
Well, and I want to talk about the same thing you want to talk about. I just think that there's degrees of notice. Was he aware that the property couldn't be rented? Yes. Was he aware that it was subject to demolition? No.
He knew it was violating the code, didn't he?
He knew that it was not up to building code.
Yes, it was
Right.
violating the code. And,
Right.
And do you have a copy of the building code in front of you?
No, Your Honor.
It's in the record here somewhere. I just can't locate it. The very first provision of the building code says that property that doesn't comply can be demolished.
Right, pursuant to the code. So 105 of the building code says that if you're
Well,
going to,
that's what they followed. They followed the building code.
they didn't follow it. That's the corner cutting.
Tell me what they didn't follow.
The building code requires that they personally serve the owner, and that if they can't personally serve the owner, that they send certified mail and post it. And so
They did both those, right?
I don't think so. No, Your Honor. There's no evidence, and they admitted that they did not certify mail the 2018, which is the only notice that indicated demolition. And there's also there's no picture of any posting.
Let me ask you, he had a box, a mailbox that he maintained.
Right.
All of this went to that mailbox, presumably, because it was addressed to that mailbox. Did he open that mailbox ever?
I think that the record details some collection of mail when he came and went from, but the problem is that when they send certified mail to a P.O. box, it's rejected. It's not ever deposited in the mailbox.
Just as the corporation, not as the individual.
I don't
There
think,
were 2 notices, right?
right, neither of which were in 2018, right?
I'm not arguing that. I'm saying there were 2 notices. One dealt with the entity and one dealt with the individual, right?
In 2016, December 2016, there was identical notices sent, one to the entity, one to the individual, neither of which mentioned demolition.
And the entity came back and the individual did not come back.
Maybe so, Your Honor. And
I just think, we ought to be able to agree on the record before we talk about the legal issues. And we just can't play fast and loose with this. It looks to me, I looked at this fairly closely, it looks to me he had notice that his house was a serious problem. It violated code. There were some pictures of wires hanging down. There was all kinds of discrepancies about it. He was mowing the lawn there regularly. He said he was there for 2 weeks making repairs or trying to work on it because of the car accident. And come back and say he never got any notice, or he was overseas, or this notice didn't contain sufficient information. The code provides, and he's imputed with the knowledge of the code, violations can be cured by demolishing the house.
well, I think that you're right about a lot of this. We're conflating 2 years into a colloquy, and the 2016 notice that wasn't returned to sender says that you can't rent the place. You can't inhabit.
He didn't have notice.
I'm suggesting that the 2018 letter, the only letter that mentioned demolition,
My question to you is, are you suggesting he didn't have notice?
Your Honor, I'm suggesting that he did not have notice they intended to demolish the
Can you
structure.
answer my question, yes or no? Did he have notice? Or
Not of demolishing the structure. No. The 2016 letter's not,
This code says that provides him notice. That's the statute. My question is, did he have notice that his place wasn't up to snuff and that they kept notifying him about that?
I think that he knew the place was not habitable. I know he knew the place was not habitable. He did not know that they intended to demolish it, and they didn't send a certified letter for 2018, and ultimately, I think that
Nonetheless, you argue that this whole thing, demolishing the property, was some pretext on the part of the government or the state to increase its tax base or its tax revenue. Is that right?
well, Yes, the city of Norfolk's out of land. It's an old municipality, and a third of its revenues from the tax base.
What's your best record evidence of pretext, or that they did this in order to increase the tax base?
Well, the briefing at 1086 to 1096 includes a footnote, I think it's 3, that mentions.
JA at 1086 and 1096, which is your reply brief?
Yes, Your Honor. The magistrate judge compelled discovery a week before the summary judgment briefs were due, and it was at that hearing that they ordered the city to provide evidence of how this scheme works, in that all of the demolitions over the last 5 years, in order to compare. So I think that what I want to say on the record is that everybody agrees they demolished for nuisance abatement. My argument, and I think the ultimate reality, is that they were doing 2 birds with 1 stone. They have an overzealous building code enforcement because it helps them gentrify, redevelop churned land.
Okay, and where is your evidence of that?
Well, I don't have strong evidence in the record. I've got the discovery compelled by the magistrate judge a week before summary judgment briefing was due. So I think that the material fact in dispute is the condition of the property, the compensation owed for what they admit is an intentional demolition of private property.
You know, you jump past this code. I've got the code now here. It's at 972. And it said, notwithstanding the above, this is the idea that they can try to remedy. They said unsafe structure, that it's unsafe or a structure unfit for human occupancy constitutes such a hazard. It should be raised or removed. Then the code official shall be permitted to order the demolition of such structures.
In accordance with.
This is the code they
Right.
have functioned under.
And doesn't it go on to say in accordance with section 105 and 106?
Well, the whole code is applicable. I mean, whatever
And I think that's
my
right.
point is,
Right.
they were functioning under the code. Now, you haven't challenged the code as unconstitutional.
And no, and
So the question, just a minute. So the question is, isn't this just a simple case of whether the Norfolk followed the code?
I don't think so. I think that if they follow the code, it's a regulatory taking, whether or not the regulation infringes.
Don't you have to challenge it? Because this is just a normal exercise of police power.
And I don't think there's a per se exemption for police power from the takings clause. That's the yawn case from this circuit.
Well, then this is unconstitutional, and you haven't challenged the code, have you?
I think that if it was properly regulated, then that would be a regulatory challenge. They didn't follow the code. They just did it. They just did it. They didn't give the notices required by the code, so he couldn't properly defend himself. There's no evidence they sent the 2018 letter at all or posted it at all. All the postings predate the actual letter that says demolition. In fact, it looks like from their own depositions that they
Keep saying they just did it like that, like it just happened overnight without any notice or ability for appellant to do anything about it. This started, the first notices were mailed December of 2016, and it wasn't demolished until December of 2018. That's 2 years. And I understand you're going to tell me he didn't know any of these notices, he didn't see any of these notices, but it didn't just happen like that.
No,
It
ma'am.
was 2 years' worth of this.
Absolutely. However, the 2016 notice says you have to secure the property and you can't rent it. And he said, great, I don't want to rent it, I'm overseas. So he secured the
He had
property.
notice in December 2016, he saw that one.
That he had to
And then
secure the
we know
property.
he saw the one in May of 2018.
I think that the May of 2018 posted the letters of 2017. I think the details that are causing some disruption between us is what he had notice of. At no point did he have notice they were going to demolish the property. The letter they generated in 2018.
What did they say in the letters, the essence, a fair statement of what did they say in the letter?
In June, they
In May, you said he got a letter in May.
right. The fair essence of the letter was your property is not up to code, enclosure the violations, and you have to remedy them by date blank. It had a blank. The enclosure didn't have a date listed. It didn't mention the word demolition, not once. And if they want to proceed according to the code, then they should give the notices required by code, follow the code, and then it's a different case.
How was
Wasn't sent at all. Wasn't sent at all. And that,
You mean they just kept it in their file?
right, they generated in their file so that their file could process a demolition. It was not served, it was not posted, it was not sent at all. That June 2018 letter, the only one that mentions demolition, is,
Reflected, that's the decision of the inspector to demolish?
it said if you don't remedy, then we will demolish.
And that's what the code says, the inspector can make the decision to demolish.
Right, and then in accordance with 105 and 106, which requires personal service, and if no personal service, then posting in certified mail. So,
Counsel, just to, I guess, frame the issue, I mean, you dispute notice. If we disagree about notice, and I'm not saying we are, but just hypothetically, then the due process issue has statute of limitations problems, correct?
right,
And so, and I know you challenge that. So, but if we're to, if you have statute of limitations problems for the constitutional claims, then we're left with the state inverse condemnation action, right?
right.
And is the primary issue you're asserting there, the issue you and Judge Thacker went back and forth on in terms of pretext?
I think that the Yawn case from this circuit best describes the situation, whether or not the taking was foreseeable, intentional. And so I think that I think because it was intentional and foreseeable, that at the jury trial, we should be able to argue that they demolished because of a nuisance. However, this isn't a police power of an imminent threat. That's a pretext to doing what they want to do, which is redevelop the neighborhood.
Yeah, I think I understand your argument there, but do you need evidence of pretext to get past summary judgment on that?
No, Your Honor.
Why not?
Because the summary judgment, there's no dispute that they intentionally took the property. It was foreseeable that demolishing the property would confiscate the real estate, and they did it without an exigency. If the police power...
Does abatement for a public nuisance require there to be like some immediate exigency? Can't they abate a public nuisance under Virginia law?
So I think that yes, they can abate according to the regulation. They didn't follow the regulation on notices. They,
Procedural issue, and I understand your arguments about that.
right. I think that they can, at the risk of paying compensation for their confiscation, because they've directly physically taken the property
You
without...
have to pay compensation for nuisance abatement, correct?
I disagree with that. I think that's the point of the Yawn case, which talks about is a per se exception for the police power, and the holding, quoting the Supreme Court, says it's axiomatic in the jurisprudence that it's not a per se violation. I think that is the problem with the catch-22 on the false premise, that there's a per se exception for the police power. If the per se exception exists, it needs to be an immediate threat.
Exception, I think it's different in kind. In other words, to exercise the police power and abate property that may be dangerous, uninhabitable, a nuisance, whatever standard you apply to it, you're exercising the police power to get rid of the, in favor of the public safety.
And that's, I think,
So it
yeah.
seems to me that when the state does that, that's not a compensable act. That's a legitimate exercise of police power that we've had since the beginning.
I agree. If it's a public exigency, which they've admitted in this case it's not. I think you do. I think you do. I think
You think the authority that you need an exigency is what case?
I think that the Yawn case best puts forward the theory of the world on the difference between a tort and a taking, and I think that a proper exercise of the police power goes back to Pennsylvania Cole, 1922, where he says, if you go too far. And so that line...
I mean, we're talking about, this developed over time, and there's an increasing deterioration, and the question is, isn't it legitimate? Is there anything that restricts the police power to something that's just about to fall? In other words, you said there.
That's
has been
the
some-
exigency, just about to fall.
Where does that
No, I
come
said, is
from?
that, what's the case that limits police power to that?
I'll read from the Yawn case, and I will point you to my reply brief, which cites authority on exigency being the requirement in order to exercise police power without compensation. And even the Virginia cases cited by both sides show that the nuisances where they summarily take property without compensation are infected cattle, infected trees, where the property has no value because it is diseased. And so I'd like to reserve a little bit of time for rebuttal, and I'll read to you from Yawn when I come back.
Okay, thank you. All right. Mr. Maleta?
May it please the court, my name is Adam Melita, and I represent the city of Norfolk, the appellee in this matter. This is a case where judgment was awarded to the defendant because the plaintiff failed to file his constitutional claims within the statute of limitations. They came a year too late. The appellant's panic that the district court ruling effectively grants the city license to demolish homes after it, 1, sends a notice that fails to reach the owner, and 2, waits 14 days for an appeal that it knows the owner is not aware of, is a complete fabrication. The district court ruling does nothing of the sort. The district court did not state that such deprivations of property are categorically allowed. A plaintiff with those facts can bring his case and can seek redress for being deprived of property without adequate notice. But he has to do that within 2 years.
Can you give us, the specific evidence that you say creates notice that triggers the statute of limitations? Your colleague says they didn't have notice. There may have been some letters, but they didn't suggest demolition. What's your response to that?
The statute of limitations begins to run not at the time the notice is given, but at the time the injury is sustained. And in this case, the statute of limitations would have run when Mr. Fox, the agent for DA Real Estate, knew or had reason to know that his property had been demolished. The record makes clear that he became aware of that later in December of later in December of the year the property was demolished. I think it was 2018. And by the early winter months of 2019, he was in communications with the city of Norfolk with a FOIA request trying to understand what happened to his property.
When was the suit filed again?
The suit was filed in December of 2021. And so it's a year too late. He
The
knew.
property was demolished in December of 18?
Correct. He knew for 3 years or thereabouts, 2 years, 11 months at the time this case was filed that his property had been demolished. And that's why he's
Point
late.
is, regardless of whether the notices were sufficient or not, the property was demolished in December of 18?
That's correct. And so he was on the clock from when he became aware of it, as the record indicates, in December of 18.
He said Thanksgiving, around Thanksgiving, was when he became aware of it.
So that's when.
No, he was on Thanksgiving, I think a holiday or something.
Correct. And he did say before the end of the
It was
year.
demolished on the 13th, and he became aware.
Correct. And so that's when the clock started to run. And so I'm a little bewildered that DA Real Estate is complaining about notice or arguing that there wasn't adequate notice, because the notice question, as I understand it, is not here on appeal. I've looked at the docketing statement. I looked at the decision of the district court that said that the Fifth Amendment case came too late. It's subject to the personal injury 2-year statute of limitations in Virginia. And so none of those issues are represented in the docketing statement. What I understand to be the issue today, what's represented in the docketing statement, is whether or not the inverse condemnation claim, the claim brought under the Virginia Constitution and the Virginia statute 8.01-187, was properly resolved in favor of the city.
Can I ask you a question about that? We have the issue of the inverse condemnation under state law and the issue of abatement of a public nuisance. Is the city's position that if you were to exercise eminent domain or make an inverse condemnation claim based on eliminating blight, that is a public nuisance. Is that public nuisance that can be a public use, a taking of, for public use under the eminent domain statute, the same as a public nuisance that allows for abatement?
We believe that it is. The definition that the Virginia General Assembly has adopted for a blighted building, for blight abatement, one of the authorized public uses for which government can take private property, says, I think it has more than one component, but the very first component is that it has to be a public nuisance. So if the city were coming in the front door, filing a condemnation petition and asking for the court to grant it title to the property through the condemnation route, it would have to prove that the property was blighted, that it was a public nuisance.
Public nuisance there is the same as the public nuisance that permits abatement?
We believe it is. It's under the
So
police
the
power.
city then, I know that's not what happened here, but the city could exercise its eminent domain rights for the same public nuisance or abate at its election, the difference being in the former, you have to pay fair compensation and you get title, and in the latter, you don't get title and don't pay compensation?
You almost have it correctly. I would argue that in neither case do you have to pay compensation. The first one, if you're asking for condemnation for blight, you are asking for title. So you want to clear the nuisance and then take title. In the latter, where it's just straight nuisance abatement, just a straight exercise of the police power, you might be removing the nuisance, abating the blight, but you're not asking for title. But neither of those are compensable, and they're not.
Is the point you don't pay compensation in the first scenario because it's not worth anything, or is it because normally in eminent domain you do pay fair compensation, right?
Right. Normally you do, but the principles in Virginia, the cases that you all had a colloquy with Mr. Sherman about, state that property that is a nuisance, that the owner has no right in their bundle of sticks to operate. Nobody has a right.
That's in the abatement discussion, isn't it?
But a public
That's the Palmer case, right?
And the Stickley case, but because a blighted property has to be proven to be a public nuisance, you still have to meet those same standards under Virginia law. And so you still have to demonstrate that the property is unsafe and a danger to others. And so that's going to categorically rule you out of any compensability.
Well, I don't know that we need to agree or disagree on that. I'm not sure. I didn't necessarily read it that way, but
That's
I
a
don't
hypothetical.
think that issue needs to be resolved in this appeal, does it?
I don't believe it does either. And similarly, I don't believe there's any issue in Yawn that pertains to anything that's on appeal in this case. You'll recall from the facts of the Yawn case that the county was spraying for mosquitoes, and the allegation of the plaintiffs was that in doing so, the county had killed their honeybee population. And so the question that the Court of Appeals resolves in Yawn says, no, there is no categorical exemption from just compensation just because the county was exercising its police power, spraying for mosquitoes. That may be true, but just because there's no categorical exemption does not mean there's still not an exemption for nuisance abatement. So if you just change the hypothetical in Yawn a little bit, you'll understand why. If the plaintiffs were not raising honeybees, but were raising mosquitoes and were investigating Eastern equine encephalitis or Zika virus, and the county came and sprayed for mosquitoes and killed their mosquitoes, that would have been a nuisance abatement. And nobody would have a right to run a mosquito farm. And the fact that Yawn comes out the way it comes out and why the categorical exemption is rejected is because the Yawn's honeybees were not a nuisance. If the city was abating a nuisance that the Yawns were maintaining, we wouldn't be worried about the holding in that case.
If the city hypothetically were to abate, as a pretext, for that there was no public nuisance, just to do it completely wrongfully, does Mr. Fox or his LLC have rights that they could have pursued?
Absolutely.
What are those options that could be pursued? I know there's forget statute of limitations, but assume you do it all timely, what are your options?
That's a due process claim. It could have been under the U.S. Constitution, it could have been under the state constitution, but it's
Couldn't you
clearly
also
a due
bring
process
tort
claim.
Perhaps? Is there a tort?
The problem with the tort claim is you could bring a tort claim. There may be principles of sovereign immunity that might interfere with tort liability, but you may have a tort claim at least colorably. But I do think the express answer to your question is provided by the U.S. Supreme Court in the Chicago B&Q Railway case that's cited in Yawn. It's described in Yawn. And that case clearly says, the constitutional requirement of due process of law, which embraces compensation for private property taken for public use, applies in every case of the exertion of governmental power. If in its execution of any power, no matter what it is, the government, federal or state, finds it necessary to take private property for public use, it must obey the constitutional injunction to make or secure just compensation to the owner. If the means employed have no real substantial relation to public objects, which governments may legally accomplish, there's the question, if it's an illegal taking. If they are arbitrary and unreasonable beyond the necessities of the case, the judiciary will disregard mere forms and interfere for the protection of property rights injuriously affected by illegal action. And so right there, the Supreme Court is saying your claim is a due process claim. That's what due process ensures. And so that's the claim that Mr. Fox could have brought had he done so timely, based on the record. I'd like to spend a little bit of time. Yes, sir.
I'm a little puzzled by the notion that a nuisance and blight are the same. I sort of understood, and maybe the cases don't agree with this, but I sort of understood blight is the economic level of a neighborhood that has lowered, and maybe for all kinds of reasons. The houses are dilapidated, there are rats in the area, half the houses are unoccupied, and the government comes in and wants to take the property to improve it with new housing or a park or whatever, and they take title to the property. Whereas a nuisance is an immediate, here in this case, the words are what?
Unsafe, uninhabitable condition.
Unsafe and uninhabitable, which isn't necessarily, it's a worse condition than a blight. Blight is just the reduction of the value of a whole neighborhood or even of a house. But it's not painted, it's not kept up, and it's a blight to the neighborhood. But a nuisance, uninhabitable and unsafe, it seems to me, is a more central police power that can be exercised.
I would respond that your comprehension of the jurisprudence is generally accurate. I do believe that Virginia has been more specific and more rigorous in its definition of blight than the general jurisprudence. I think that's all a consequence of the measures that were taken by the General Assembly post-Kelo to clamp down on what this particular Commonwealth legislature determined to be an eminent domain abuse that occurred in Connecticut.
Right. And I had the same initial reaction as Judge Niemeyer, but I think if that were right, then the issue of whether there was a nuisance would be potentially material. In other words, district court said whether there's a nuisance or not is not material, because if there's a nuisance, you can abate. And if there's not a nuisance, you don't have a public use.
That would have been the principle, but I think the district court does a thorough job of identifying in the definition of a blighted property, right there in 1-219.1, that because one of the necessary elements, I think it's the first of three elements that have to be proven for a property to be deemed blighted and therefore eligible as a public use for which it can be taken, is that it has to constitute, the property itself has to constitute a public nuisance. So that the property down the street, the barber shop that's in perfectly good condition.
It would be a narrower constriction than Kelo, whereas.
Exactly. And by narrowing it, they essentially trued up and made coincident
So whether
the definition
or
of a
not
nuisance.
Blight and nuisance might, in a generic sense, be different. Under Virginia statutory law, they've equated them, now, post-Kelo.
Correct. That is what the district court held, and I believe that is consistent with what the law says. Judge, because it's an issue in the, Your Honors, because it's an issue in the briefs, I'd like to spend just a few minutes on the issue of Darby. This was the later identified authority that was submitted by the appellant, the 2024 case, which I don't believe breaks any new ground. Darby is the case, it arises from the federal government's prohibition against certain evictions. And it's a case that the appellant relies on for the principle that illegal takings can sometimes still result in a right to compensation for the property owner. You'll recall from our briefing, and you might intuit from the district court's opinion, that any illegal act automatically precludes the property owner from being eligible for just compensation. And Darby says that's not the case. The problem with relying on Darby is that Darby doesn't apply for 4 reasons. First of all, Darby is a Fifth Amendment case. It's a Tucker Act case. The 2 cases it relies upon, Darby does not plow any new ground. It relies on the Del Rio drilling case and the Ramirez case, and just says we're doing the same thing we did in those other cases from, I think, 1998 and 1987. But those are all Tucker Act Fifth Amendment cases. And as the court is already aware, the Fifth Amendment case was untimely and was dismissed for being too late. The second reason why Darby doesn't apply is because, first of all, it's a Fifth Amendment case and they don't have a Fifth Amendment claim. Second of all, the Fifth Amendment claim that Mr. Fox did have was dismissed for being too late. The third reason why Darby does not apply is that Darby recognizes that there are exceptions to the rule that says even an illegal act, so long as it's authorized, can result in an opportunity for the property owner to realize compensation. And the exceptions to the Darby rule are where the legislature has expressly said, no, you do not have authority to acquire private property for public uses in specific instances. Darby analyzes 3 specific examples. It analyzes a taking of property in Southern California by, I think, March Air Force Base, in the Southern California financial case from 1980. It analyzes the Huey versus U.S. 1910 case where the Civil Service Commission was occupying more floors than it had rented in a building, and the landlord wanted to be compensated for the additional floors, I think the basement that the Civil Service Commission had occupied. And then it analyzed the North American Transportation case from 1920, where General Randall of the U.S. Army had taken property for military purposes in Alaska that he was not authorized to take. And in all of those cases, Darby says the legislature has expressly precluded these people, these entities, from having the authority to take property. And so there is no just compensation for the owners in all of these cases. And that's exactly the situation we have in the instant case. Virginia's General Assembly has expressly told localities that they cannot take property to increase the tax base. They cannot take property for economic development. And so even if you were to apply the Darby rule in Virginia, which Virginia has never done, there is an express exclusion from the authority of localities to take property to increase the tax base. So any apparent authority to take for that purpose has been excluded and therefore falls within the exception cases, much like March Air Force Base, General Randall, and the Civil Service Commission, and really does not fit within Darby. And the last reason why Darby does not apply is that the Virginia Supreme Court has expressly rejected any rule that even looks like Darby. In State Highway and Transportation Commissioner versus Linear Farm from 1987, the Virginia Supreme Court wrote, quote, "We have consistently adhered to the view that the eminent domain provisions in the Virginia Constitution have no application to tortuous or unlawful conduct. And then even more clearly in 1954, Erickson versus Anderson, neither the Virginia Constitution nor the state statute, quote, has any application to unlawful or negligent acts of the servants, agents, or employees of the State Highway Commission, which may result in damage to a property owner. There is no state statute which authorizes the officers or agents of the state to commit wrongful acts. On the contrary, they are under the legal obligation and duty to confine their acts to those which they are authorized to perform by law. And here's the most important sentence: if they exceed their authority or violate their duty, they act at their own risk, and the state is not responsible therefore. So the Virginia Supreme Court has rejected the Darby concept, and what DA Real Estate is asking you for today is to allow them to bring a due process claim, a claim that they had to bring within 2 years, allow them to bring that within 3 years, relabel it as an inverse condemnation claim, and then adopt a Darby rule and expressly overrule the Virginia Supreme Court, all within the context exclusively of the Virginia Constitution and the Virginia statute. There are no federal constitutional issues left. They're asking you to rewrite Virginia law.
Thank you.
Thank you.
All right. Mr. Sherman.
I went over my time before, and so I'd like the opportunity to just explain that if the theory of the whole case, and then accept your questions as they fit in, because I think a lot of jumping around isn't serving our interest into the holistic view. If they'd taken the case with straight condemnation, they could file a petition, and then we could raise an affirmative defense and say, it's not a nuisance, it's not a blight, you're not allowed to take it. We could enjoin the take, or we could submit to it and get it to a jury verdict. Instead, they've gone straight to abatement, so there's no structure to evaluate to determine how bad a shape it's in. There's no defense to say, don't do it, it's already done. And all we're asking for is a verdict. We're asking for the opportunity to put on compensation because nuisance is material to whether or not that structure had any value. And nuisance is defined by the Virginia Code as a menace to society. Blight is defined by 1-219.1 as unsafe and either a nuisance or uninhabitable. So
how do you, your position, you disagree that, that the reference to public nuisance in the statute in defining blight is the same as nuisance for abatement purposes?
it's very close. I don't think it controls the outcome here. I think what controls the outcome is that they've gone ahead and done the abatement. So we can't enjoin it. We can't say it's not done right. And since they didn't follow the building code regulation as to properly provide notices and personal service, if a sheriff serves you something, that's serious. And so the only option we've got is coming to court on an inverse condemnation. They say those.
Why is that? Why couldn't you bring a due process claim if they just they abated your property? It
Right.
It was brand new with no problems, and they said it was a nuisance and you abated it. Why couldn't you bring a due process taking claim?
Right.
You clearly have that right.
Well, maybe the city cites precedents.
Say maybe.
The city cites precedents of this court, Yates in 1986 and Presley in 2006, to say that your process is post-deprivation inverse condemnation. All roads lead to Darby in this case, because Darby says exactly what needs to be said here, which is that if there's not a Fifth Amendment remedy, if there's not an inverse condemnation, there's no meaningful remedy at all, because what they did is take the property. And so in 52, 53 of the record, 1071 through 1073 of the record, the city cites two precedents of this court. The Virginia Supreme Court and the city v. Lee has not expressly adopted it, but not outright rejected it either. So their argument and persuasively arguing is as recently as an unpublished decision from the Court of Appeals, Virginia State Court this year, is that your process is inverse condemnation. And so they're abating. They're the people with the least amount of resources, connections, and education are the ones that are most hurt by this, because they're not going to spend $60,000 to sue the government for this kind of colloquy. and to debate whether or not it was a nuisance when there's no building to even look at. So what's fascinating about this case and why it's the right case to bring to Your Honor's attention is because the corporate designation, they say it was not unsafe. It was not a threat to public health safety. That's plain as day in the corporate designation binding on the city. 530 and 533, they say it wasn't a threat to anybody. As long as nobody's living there, it's not a threat. And so nuisance is a material fact in dispute, and that's what should go to the jury, because the only issue left to resolve is what it was worth. If they clearly took it, they intentionally took it, which is what yawn stands for, is whether or not the taking was foreseeable. And the line between a tort and a taking is, did they intend to do it, or was it negligence? Was it some sort of rogue actor? And so nuisance is material, and it relates to value. That's all that's left to decide. Yawn rejects a per se police power exception. I'll quote, that government actions taken pursuant to the police power are not per se exempt from the takings clause is axiomatic in the Supreme Court's jurisprudence, citing Arkansas Fish and Game, Supreme Court 2012. The court has consistently rejected this argument when deployed to urge blanket exemptions from the Fifth Amendment's instruction. And then citing Lucas, which was a 1992 Supreme Court case, quoting Lucas, if instead the uses of private property were subject to unbridled, uncompensated qualification under the police power, the natural tendency of human nature would be to extend the qualification more and more until at last private property disappeared. So it goes on to talk about that the legitimate exercise of governmental powers and the degree which the invasion is intended or foreseeable. So I think that the notice issue does bear some impact in that if they had properly followed the regulations set forth by the building code and the state law, then this is not the same case. Because they're in 2016, they're saying, look, you can't rent it in its condition. In 2017, they said, somebody's broken into it. It's got to be secured. At no point in the communications in April or May 2023 did they talk about knocking it down. And then the June letter that they never sent, never served, never posted, said demolition, but it only stayed in their file. Nobody got it until we did discovery in this case. So the yawn analysis talks about how the press releases related to the bees would impact the foreseeability. And I think that's where the notices matter, because if he had true notice that it was subject to demolition, then it's a different case. He didn't. The 2016 notice says don't rent it. The 2017 says make sure it's secure. Somebody's broken into it. And not until 2018 did they put the word in their file, although they never told him. So I think that the language about necessity is quoted by my colleague, and that's what the problem is here, is that the validity of a police regulation depend on the circumstances of each case and the character of the regulation, whether arbitrary or reasonable, and whether designed to accomplish a legitimate public purpose. If the means employed have no real relation to the public objects which government may legally accomplish, if they're arbitrary and unreasonable, the judiciary will disregard mere forms and interfere for the protection of rights injuriously affected. And so that's the Pennsylvania coal case, the seminal case, that property may be regulated. If it goes too far, it's recognized as a taking. Penn Central, 1978, a use restriction may constitute a taking if not reasonably necessary of a substantial public purpose, or perhaps has an unduly harsh impact on the use of property. And so that's, I think, the material issue here, and I think that's what the jury's got to decide, and I think that's what the McIver case from 2020 of this circuit also held true, is that nuisances are best decided by a local jury, because there's an ebb and flow of use of the property compared with the needs of the public. And what better than the folks who are local to South Norfolk to understand that, yes, a property may get broken into and requires securing. However, that doesn't mean that it was going to fall down. They said themselves it's not going to fall down.
Okay, I think you're rather.
I'm sorry, Your Honor. Yep.
Thank you for your argument. We'll come down and greet counsel and then proceed on to the next case.
Thank you, Your Honor.
Next case we'll hear this morning is Belton versus Loveridge. And Mr. Bader, whenever you're ready, we'll hear from you.
Good morning, Your Honor. May it please the Court. Stephen Bader from Cranfield Sumner in Raleigh, North Carolina, here on behalf of the appellant, Heather Loveridge. On November 1st of 2019, Heather Loveridge, a uniformed Charlotte police officer, fired at her colleague, the plaintiff in this case, a plainclothes officer named Clarence Belton. The shooting happened after Belton and several other plainclothes colleagues were involved in a shooting inside of a suspect's garage. It happened seconds later as Belton came out of that garage towards Officer Loveridge. The district court denied Officer Loveridge's motion for summary judgment. There are two issues before this court today. The first is jurisdiction that my friend has raised, whether this court can review the denial of summary judgment. And the second is whether Officer Loveridge is entitled to qualified immunity under the undisputed facts. And to begin with the jurisdictional argument, this court can review the denial of the denial of qualified immunity at summary judgment under the collateral order doctrine if the decision turns on a question of law. Whether an officer's use of force is objectively reasonable is a question of law. And when the
Not based on these, you'd have to have us rewrite the facts as the district court found them.
I don't agree with that, Judge Thacker, and here's why. The court sets forth the parties' contentions and says the plaintiff makes a contention about the light, the defense disagrees. Plaintiff makes a contention about whether she was in fact hit by the bullets and the defense disagrees. And then the key one that they keep coming back to, which is the plaintiff takes the position that Officer Loveridge should have seen or recognized him as a plainclothes officer before the shooting. That's not a question of fact, that's a question of reasonableness. When looking at this court's precedents, when there's an evidentiary dispute as to how something happened, then that dispute needs to be resolved first.
It seems to me the district court I think you're right, reasonableness is a question of law. I mean, the Supreme Court has said that, we've said that. But if there are questions of fact about what happened, those can preclude the award of sovereign immunity. And I think there's a good argument we don't have jurisdiction if the denial of qualified immunity is based on disputed facts. It seemed to me the district court was saying that. Where I thought you were going to go was, the qualified immunity analysis has two prongs. And what we don't have, or what it seems questionable to me is whether we have from the district court a determination that if you construe the evidence in the light most favorable to the plaintiff, that right is clearly established. I mean, the order cites the clearly established proposition but doesn't identify the right and doesn't say why it's clearly established. And that may not matter if it's a clear question for us, but it matters a lot if it's not a clear question for us. So, maybe you want to make the argument that the facts here are undisputed and we can look at it. I think that's a tall order. I think your better argument is to say, we've set forth how you do qualified immunity, and we can't really judge the clearly established issue based on the district court's order.
Well, and Judge Quattlebaum, I think that's right. And I'm not necessarily accepting your challenge, but I want to just deal with the idea that there's a dispute here. And looking at this court's recent decision that we cited in supplemental authority, Rambert versus City of Greenville, what this court said is that the district court denied summary judgment. You had an officer that was involved in a shooting with a mentally ill individual. And the district court said that there was a question about whether the officer should have recognized that that individual was mentally ill. And then there was a related question as to whether making that recognition a mentally ill individual who's unarmed would pose a threat to the officer. That's not a question about how the events happened. That's a question about how the officer perceived the events and responded to the events, which is functionally
At least two of us know a good bit about Rambert, probably
yes,
three of us. But, you know, I don't want to get too off track, but in Rambert, the question was there was only one way this could be perceived. And in this case, you know, the issue is should Officer, should Officer Loveridge have realized that that Officer Belton was an officer or not? And there's a dispute about whether that was something that was apparent or not. So, I mean, you can keep going down this thing.
We can't consider disputed facts.
well, let me then get to the qualified immunity issues that Judge Quattlebaum laid out, because I think we can still get to the same, our request for relief, which would be to reverse and find that Officer Loveridge is entitled to qualified immunity. When we look at this court's case law, the two cases that are the best analogs for these facts are McClanagan versus Carnes and Milstead versus Kibler. And in both of those situations, what you had was an individual, an officer on scene, where there was a threat in the form of a gun. Either an individual who is said to have had a gun in such a way that they may intend to use it, or an individual that in fact did have a gun, had made a threat to another, such that another officer on scene had fired in response. And after that happened, the officer had seconds to react to somebody coming at them who they did not know. And in response to that threat, chose to fire. And in both instances, what this court has recognized is that qualified immunity protects an officer from a split-second decision to use lethal force in a situation like that.
Cases?
They were not, no, Your Honor.
So yeah. So those are situations where the victim of the shooting was someone that created a split-second situation.
Yes, but I would add that in both of those cases, those plaintiffs were not suspects of any kind of a crime. They just happened to be in the wrong place at the wrong time.
And also, you just said again that they did not know. That's going back to the fact here. That's disputed whether or not Officer Loveridge knew that Officer Belton was not a suspect before she shot him 14 times as he was crawling out of the garage.
What I would say to that is that the testimony from Officer Loveridge is that she did not recognize him as such.
That's what I keep telling you. You keep going back to wanting us to revisit facts that the district court found to be in dispute, and that we cannot do. I think well, I'm not going to help you. You go right ahead.
Well,
I was going to go back and question whether, this goes back to what Judge Quattlebaum was asking you, is whether there was a constitutional right at all implicated in the sense that the Constitution protects unreasonable searches and seizures. This was a seizure, intended seizure of this fellow McConaughey, whatever his name was. She was not intending to seize Belton. And the excessive force was apparently directed, if you accept that it's excessive, directed against Belton. But that was not a seizure. That was a tort at worst, a common law tort. She made a mistake. The difficulty I have, even in the analysis of the facts, is that we have always asserted that we have to take the facts from the perception of a reasonable officer in her position. And so we can't, she clearly did not recognize him as Belton. The argument your counsel makes is she did recognize him in Belton and shot him because there was good light there. Now, that is an unreasonable conclusion, and I think it's an unreasonable fact. There's no suggestion that she intended to shoot a fellow officer. She shot him by mistake. I think it's the record pretty supports that. Now, if you sued a fellow officer, it's a friendly fire case. This is not a seizure of a criminal suspect where excessive force is being used. So the question is, where is the clearly established constitutional right of this man who has been the victim of a tort when there was no seizure made? The Fourth Amendment protects against a seizure, and she wasn't seizing Belton.
Well, that's right, Your Honor, and I think to sort of unpack that, I think number one, there is no constitutional violation at all. Certainly the court could come to that conclusion since that wasn't
And that's a fair point, and to me, that's why we got to discuss clearly established. I don't recall if you cited them, but there's 2 Ninth Circuit cases and 1 Eighth Circuit case that involve a similar situation to this, a police-on-police fire where the officer was not, there was an intended shot, but a mistaken belief that it was an officer. And they said that, a shooting like that is excessive force and is a Fourth Amendment violation. And outside the officer world, we've said that, right? I mean, we say excessive force is a taking. We could debate whether that's really faithful to the language of the Fourth Amendment, but I don't think have the option of doing that as a panel here. So there is some law out there that would say, hey, this is not just a tort, it's a constitutional Fourth Amendment issue. But that's 2 Ninth Circuit cases, 1 Eighth Circuit. There's no Fourth Circuit law, there's no Supreme Court law. And we've really not really framed the right to assess that. And so it seems to me that's the issue here is we say there's disputed questions of fact, but there may or may not be, even in the light most favorable to the plaintiff, a clearly established right here with respect to a mistaken shot at an officer.
And then I think that's the way you do it, Your Honor. I think that's the way you can look at it. I mean, we did point out.
Okay, let's assume we're doing that. We could always send it back and say, district court, do that. I didn't see a case that said the other either. Right. I didn't say there's not another circuit that says, well, no, this is a tort. And there's law that says police have don't have watered down constitutional rights. So true, we don't have a case, and maybe that's enough, but I don't think the absence of a case is fatal or absolutely means it's not clearly established. What's the basis of saying it's not apparent that if you shoot an officer that you perceive that again, in the light most favorable to the plaintiff, you shoot an officer who has all the appearance of an officer, that's not a taking? What's your argument there?
Well, there's no cases from this circuit that would involve even remotely similar facts that they would put in officers such as Officer Loveridge, who's asked to come in and provide backup support for plainclothes officers that she's not interacted with before, that they would have a clearly established right 2 to 4 seconds after a shooting involving this suspect to be free from any mistaken identity or mistaken shooting.
The question is probably a little more complex than I posited it. It seems to me when you shoot an officer, even if that officer is fully dressed and you could recognize he's an officer, if you weren't attempting to seize him, you just sued him, it's murder. It's a crime. But the Fourth Amendment is what we're looking at, and the Fourth Amendment limits the way we investigate and prosecute crimes. We search, limitations on searches and limitations on seizures. And if the one officer was trying to seize the other officer as a suspect of some kind and shot, this is an excessive force case under the Fourth Amendment. But when the officer does not intend to kill his own kind in the sense of another officer as part of his seizure of that officer, we have a tort maybe, but we don't have a Fourth Amendment. Now that doesn't fully answer it because the intended seizure here was against McConaughey. And McConaughey was not there, and this was a mistaken shot. The question then is, was this excessive force against McConaughey when the woman appeared at the door with a gun, and then gunshots appeared? 9 gunshots were fired before Loveridge fired anything. And so and I looked at the video 3 or 4 times, and it was instantaneous. I mean, her shots were probably in the case of 2 or 3 seconds. She's moving across the front of the garage and firing her shots behind the officers as they're exiting. It's like she's providing cover. But quite apart from that, the question is, she was not seizing Belton, and she never intended to seize Belton. She was trying to seize McConaughey. The question is that the framework for assessing excessive force against Belton? I'm not sure about that, but my bigger question is, do we have any case law that's going to alert the officer to that?
Well, to that particular question, no. To your earlier comment, if this was in fact McConaughey, then you're squarely in the McClenaghan-Milstead cases, and the notice to the officer would be that 2 to 4 seconds, which is what I calculated, right after an officer involved shooting an objective officer.
I had 3 seconds myself, but that's everybody. But it is very instantaneous. She fired. I don't know. It must have been I don't know how she got those shots off that quick, but she fired them and moved around. She was moving around, and the officers were exiting, and she fired in there, and it looked like she was playing cover for them as they exited. But the question is, she clearly did not intend, nothing in the records, intend to hit Belton. That was a mistake.
That's absolutely correct, and qualified immunity protects officers for reasonable mistakes. We would ask that this court reverse the denial of summary judgment for Officer Belton and find she's entitled to for Officer Loveridge, and find that she's entitled to qualified immunity. Thank you.
Thank you, Mr. Bader. All right, Mr. Hayes.
Your Honors, may it please the Court, my name is Mark Hayes. I represent Officer Clarence Belton, the plaintiff in this case. You have heard a lot of discussion about facts, but really, that's not the place for this. This is not the place for that. This court is constrained by the findings that are in that order, and that's where we have to start. But that being said, I do want to go over some of the important facts about this case, which are that we have a respected veteran police officer, and Officer Belton, who was wounded. He was crawling on the ground. He was trying to escape danger. He's crawling along the side of the garage, not toward Officer Loveridge.
You know, if Loveridge understood it was Belton, this would be a grievous case. And unfortunately, you identify the facts, the factual dispute in this case in your brief as to whether she recognized it was Belton or not. This is what you say. Quote, an officer cannot enjoy immunity for shooting someone she knows to be another officer legally performing his duty. You say again, this court must presume that the defendant Loveridge recognized plaintiff Belton as an officer before shooting him. Now that's where you couch the factual issue, that whether she knew it was Belton or not. My suggestion to you, and you can now answer this, is that totally unreasonable suggestion of factual question, because that presumes that if she knew it was Belton, she would have shot him, or she did shoot him knowing it was him. That's murder, and that's not what's before us. What's before us, I believe, is she fired in that garage. Identification was not totally clear, but she made a mistake. She did not intend to hit Belton. She clearly was either trying to cover for their escape, or she was trying to hit what she maybe thought was McConaughey. I don't know that answer, but my whole question comes down to is, this is a friendly fire case, like in the military. One officer is trying to do a job, another officer is trying to do a job. Belton is a good officer trying to do a job. He got hit earlier. She was trying to do a job. They ended up, by mistake, hitting each other, or she hit him with bullets. The question is that a constitutional violation to hit a fellow officer in that kind of circumstance? And I step back and I wonder, Well, she's not making a seizure under the Fourth Amendment of Officer Belton. She hit him by mistake when carrying out her duties. And so it's a lot. I've raised a lot, but that was my concerns, and I'd love to have you address those.
Your Honor, based on the finding of disputed fact in the order, which is where we have to limit our universe because this court cannot get into the facts, based on that finding that she saw him, knew he was an officer, and still shot him, a jury could do one of two things. First, it could conclude that she actually fired at him knowing he was an officer subjectively in her mind. And you may think, how is that possible? Have you ever been so overwhelmed with emotion, for example, that you hit a wall and you put a hole in it? Did you want there to be a hole in that wall? Did you want your hand to possibly be broken? No. But could I say I didn't intentionally do it? I didn't know what my hand was? It's not a mistake.
How can you have a question of fact on that in view of her position that it was clearly a mistake from her point of view? Now the question is to contradict that and create a fact. All you've got is the notion that she could have recognized him in view of the circumstances, that there was light and he was crawling. I don't know how she would have recognized him on the floor because he had a jacket on, his police identification was on his front, and he was crawling.
Your Honor, I have more than that because I have...
Whatever it is, I mean, all the evidence you have that he could have been seen. The question is, do we have any evidence that she recognized him or thought it was Belton?
We have that the finding that we are bound by this court, that she looked at him, saw he was a cop, and shot him. From that, the jury could infer she actually subjectively intended to. We don't have to go there.
It's inferring murder, then. I mean, that's just straight-on murder. You see somebody, you recognize them, and shoot them for no purpose? Come on.
I mean, perhaps, but we are bound by that order. But again, we don't have to go there. We have the...
Can I interrupt and go finish your point?
I was just going to say, we don't have to go there. The jury, we're basically paralleling probable cause. So the jury just has to put an objective person in that point of view. And if the objective person in that point of view, after seeing someone and still shooting him, wouldn't have done that, well, that's the whole point. That proves it was unreasonable, which proves our case.
It's not actually how it works. It's not a jury determining what's reasonable. That's the court determining reasonable, and the jury just resolves the disputed facts.
But on those facts.
But that's I want to get to a separate, I get more issue, or maybe separate, maybe related or not. Will you tell me what is the right that you say the Officer Loveridge violated? Can you define the right that you're asserting here?
I will do my best to do it, but I'll also point, Your Honor, to the Ailman case, especially when it's talking about Cooper. Really gets into that sort of stuff about, does he have a clearly established right? That's where that's really talked about well. But I think just intuitively, a seizure, what is a seizure just in common, parlance? It's to stop someone. Was Officer Belton moving? Yes. Was he stopped because he was shot? Yes.
I mean, I think it's your obligation to tell, the law requires the court to decide whether the constitutional right that you're asserting is clearly established. And so, and it can't be at a high general level under the Supreme Court authority. So, I think you have an obligation to say what's the right that you say is clearly established. And I'm just asking you to tell me what it is.
It's the right not for a unarmed person where there's no cause to think this particular person is armed, just like that there may be guns out there, and that person is shot. That's a seizure, and that's what happens in Ailman.
Okay, yeah, but and maybe that does it, but that doesn't account for this being an officer. And maybe you think an officer has no relevance in here, but Judge Niemeyer's asked some questions about it. I asked some earlier questions, and it might be that the fact that your client was an officer, bears on the clearly established question of whether there's a clearly established right.
Well, Your Honor, I would urge this court not to construct a argument for the city and for defendant Loveridge. If you take a look in the JA, it's got the transcript at the end of it. If you look at page 501 of the JA, you'll see the only time, as far as I can tell, and of course I was scanning this quickly as y'all were asking him questions, that's the only time clearly established is even mentioned, and there's just a perfunctory We don't think there is one. There's
The Supreme Court tells us we have to, we don't, a lot of people think qualified immunity is crazy. A lot of people think it's great. We're just following the Supreme Court law. The court has, if qualified immunity is raised, there's a way you got to do it. You got to say at prong one, was there a constitutional violation? Construing the evidence in the light most favorable to the plaintiff. The district court really didn't do that, but he probably implicitly did that. We'd probably be nitpicky for us to say
Yes,
that,
sir.
although he could have done it more clearly. But he didn't do anything with the required separate prong. He didn't say anything about what the right was and whether it was clearly established. And the reason you got to do that is that the Supreme Court tells us qualified immunity has to be resolved at the earliest possible way. And if you don't kind of show your work there, we don't have a real way to say, hey, was that legal determination? That's a question of law. Whether there's a right that was clearly established. I don't know what the right the court considered, what was the right that the court considered. I certainly don't know why it said it was clearly established, if it even said that. So what are we to do here with that?
Well, I think obviously it's implicit in the order, but at worst, I guess you would have a remand for clarity from the district court.
I don't know if it's implicit. The reason I say this, you tried to characterize the right a minute ago as anytime you shoot somebody, it's a seizure. And the question is, that would mean every common assault on the street, murder on the street is a constitutional violation. I think the constitutional seizure relates to law enforcement. The state cannot search and seize an individual
Right.
Without due process, without probable cause, and without excessive force.
Right, and
So we have a law enforcement effort behind every seizure that's being analyzed. The law enforcement effort here was not to seize Belton. And Belton was not being seized, except in the common dictionary sense, but not in the constitutional sense.
I don't know
The constitutional sense would be the only person that could have been subject to the seizure here was the woman at the door and McConaughey. And so that's my problem with the principle that we have an officer accidentally shooting another officer who the first officer did not intend to seize, how that is a constitutional violation. And then, of course, you have to have it where it's clearly understood by any reasonable officer.
Right. Well, of course, you have to have a state actor, so your examples of like assault on the street. So that's what we're looking first. Second, I think I keep hearing maybe an implication that there has to be an intent. I don't think that there does.
It has to be de facto a seizure under
Right.
Constitution.
And he's certainly stopped when he gets shot 14 times.
That was not a constitutional seizure. He was not a suspect.
Well-
The law was not being enforced against him. He was not being brought in by the state. He was accidentally shot. And so the question is that a constitutional violation? Now, maybe there is some principle that you could apply the seizure effort against McConaughey. That may be a legitimate argument, but I don't think you can just clearly say shooting a fellow officer violates the Constitution.
I don't have a case for that on Your Honor, but I will say, I will just, I guess, urge that I feel like intent is slipping into this when it shouldn't.
Well, there is, I actually think intent is required. Intent to shoot is required. I think there's a debate, about whether if you shoot someone, Officer Loveridge intended to shoot. The question is, did she, when she shoots someone that she has mistakes for someone else, is that a seizure? If we're talking about non-officers, there's some law out there on that. And we're talking about officers, the only two cases I could find, and no offense, but y'all didn't help me out much, was the Ninth Amendment and the Eighth Amendment cases. The Ninth Circuit and the Eighth Circuit cases. And so there's some support for your theory, but they're not Fourth Circuit cases and they're not Supreme Court cases. So that's kind of my situation is, how do we really know whether this is clearly established we're usually a reviewing court, not the ones doing that in the first instance. Maybe we can do, maybe it's clear enough here where we do it in the first instance. But we don't really have any way that I can see that the district court says there's some questions of fact, but it doesn't allow us to review the clearly established prong of the analysis.
Right, Your Honor, and I guess I would bring this back to just as a matter of, who's bringing this motion? They are. They need to make these arguments. We shouldn't be constructing it for them. If they didn't make it, which they didn't, then I don't know that we should remand and give them another bite at the apple. I certainly haven't had a chance to respond to this. I'm doing it flat-footed because it wasn't briefed.
Yeah, well, I hear you there, but I mean, immunity is a question that's before us. I mean, whether it was teased out as well as it could, I think your point, has some merit there.
And were it granted, then we would be unwinding that ball, but it was denied, and so they didn't make their case. Just looping back to the interlocutory aspect of it, again, we're limited to that order. If we see appellant making arguments based on citing to the record and dancing around it, that every one of those is a concession that they are moving outside the bounds of this interlocutory order.
Can I ask you this, and maybe I don't fully understand it? What are the core disputed facts that you think are material to addressing this issue in the context of the questions we've raised?
Right, well, we can just look on page 437.
I'd like you to summarize it for me.
Sure. So how well lit the garage was,
Okay.
what exactly Leverage could see before she started shooting at plaintiff, so before, in the garage, whether the bullets struck and or caused plaintiff's injuries, which really hasn't been contested here,
It's not disputed.
and whether Leverage, quote, had the opportunity to see plaintiff before the doors breached. Leverage denies that. Plaintiff further contends the evidence shows Leverage could see that plaintiff was a law enforcement officer before she shot him. So if we...
You're reciting exactly what I thought, which is the whole question of a disputed fact in this case, as I understand it, is whether Leverage saw or should have seen Belkin as a law enforcement officer and not the suspect.
Right, that
was based on the circumstantial facts of lighting and identification and the facts you've talked about.
right.
If that fact is resolved against her,
At trial.
at any, doesn't matter when right now for my purposes, because you say it's a disputed fact, then you have to conclude that this officer, on one set of facts, saw Belton, recognized him, and shot him.
Yes, Your Honor.
You said that 3 times in your brief, that is the disputed fact. What if I conclude that is an unreasonable conclusion?
I would say...
In the factual context.
I would say...
There's really no factual dispute that's material to the immunity issue. We would have to assume, to make that a material fact, that this woman, functioning as a police officer, firing her gun after 9 shots had been fired, saw a fellow officer and deliberately hit him. This is what the factual conclusion leads to. So my question is, really, is that a factual dispute?
It is, Your Honor, and I think perhaps if I parse out the word mistake a little bit, I remember when I was in my young 20s, I changed the brake pads on my car for the first time without my dad around. It was very frustrating. Rusted old car. At some point, I put a wrench on it, took a hammer to it, started tapping it. The bolts would not budge. And I got so frustrated, so flushed with emotion that I took that hammer and I pounded it on the pavement. Did I want the pavement to break? No. Did I like the feeling that wrung up my arm? No. Was it unintentional? Was it a mistake? It was a mistake in the sense I regretted it, but was it a mistake in the sense of I didn't know what I was doing. I didn't know I had a hammer. I didn't know that I was hitting. I didn't hit my toe. I knew I was hitting that pavement. She could have gotten so flushed with emotion that sometimes you just try to release it.
Evidence of that. I saw the videotape, and I looked at it. Regularly, I looked for different things. I looked for her movement. I looked for when the shots were fired. I looked for when the other officers were exiting. Every time I looked through it for a different purpose. And I looked at her basically trying to exercise an officer's role. That is to either stop the person that they were seeking or to protect the officers. But she was shooting behind the officers. Two of them came out right away. And then after she started firing, a third one came out. But Belton was on the ground crawling, and that's who she ended up shooting. But the question I have is, where is all this business about, you're talking about her anger and all this emotion? She looked very composed.
Look, it comes from...
Afterwards, she stood there and put her gun in her holster and...
Your Honor, it comes from, I think, the same place of, like, we're kind of jumping the gun to intent. I'm not trying to go there. The question is...
You were raising all this emotion, the fact that she got angry and slammed her hammer on the concrete, I mean...
Yes, Your Honor. I think implicit, I guess maybe what I'm getting, and maybe I'm misunderstanding, is the question behind the curtain is, she's a good guy, he's a good guy, why would a good guy shoot a good guy? And I'm providing an answer to that.
We don't need the why. We don't need
You're right, Your Honor. We don't need the why. All we need is the order.
State, the government, through an officer, seizing somebody else in respect to law enforcement. And we have the government, through Loveridge, firing bullets against somebody else mistakenly and not trying to seize that person.
Your Honor, I would just say that the order precludes that mistake. But let me just touch on a couple things. I have very short time here. If you're going to jump the gun down to is it reasonable or not, and what would a reasonable officer do? If we're getting down to that issue, I think it's very important.
For us to decide?
I don't think it is for this court to decide.
I thought reasonableness was a question of law.
I'm sorry, yes. The question of reasonableness, if we're going to try to say what would a reasonable officer do, I think it's very important to look at what the city itself did. The shooting review, 5 cops on that board. They all said it's unreasonable, not just unreasonable, not justified. We're not just going to punish her, we're going to fire her. Goes to internal affairs, more cops,
And it would have
same
been
thing.
unreasonable if we assume what she is saying was true, that she thought it was the suspect, because there was not,
Right.
arguably, there was not
And that-
a threat for that amount of excessive force when somebody is crawling on the ground towards you. It's far, far different than the facts in Rambert.
Exactly. If we're going to reach an additional issue that was argued at the hearing but didn't make it into the order.
I believe 9 shots have been fired before she fired.
Right. Let me just go to Thacker, Justice Thacker, or Judge Thacker's question first, if I may. That there was no immediate threat. You look at Ailman. That was argued.
Does anybody know where all the shots were coming from when she's sitting there trying to protect the officers? There were 9 shots fired, all almost simultaneous to hers. A few seconds after those shots were being fired, she's firing shots.
Right.
Now, you tell me there's no danger, there's no response, quick response?
She is responsible for her 14 shots. And if you watch the video, which I urge this court to do in super slow motion if you can,
She's backing up.
she is backing up.
There are vehicles that she
Exactly.
could take cover behind if she really perceived
Right.
a threat from a man crawling on the ground when there are others running at her.
And when she first approached, she actually did that very thing. She took cover. She's able to back away.
The officers inside who were running out. That's what it looks like. Because as she's shooting, 2 of the officers are coming out, and she's shooting behind them, and then a third officer comes out. And while she's standing there at the garage, and she's not retreating, she is firing behind them.
Right, but I would
She's
loop.
protecting their rear.
I would loop back to Ailman as well. They're standing there with a guy with a gun. The court says he is a threat, but he's not an immediate threat. Is the person who's crawling not crawling toward her, not deviating toward her as she's back away, she's able to move away? Is he an immediate threat?
Where she knows where the 9 bullets came from, the shots fired ahead of time. There were 9 shots fired. And is she supposed to figure out where they came from before she fired?
No, Your Honor, but we're following her 14 shots.
Yeah, she fired 14 in 3 seconds.
Right, she fired her 14 shots while backing away. He's not headed toward her. He's on the ground. He doesn't have a gun. Nobody says, he has a gun.
She doesn't even say he has a gun.
Right, there's none of that at all. And so does she have to shoot him? Let's just assume he's a suspect.
Still, the woman in the door too, isn't she there? She came to the door with a gun.
I mean, we don't see what happens to the
Oh,
woman.
we don't know where the shots came from, but this is the scene. In other words, there's a woman comes to the door, she has a gun in her hand. They battered the door down, she comes with a gun in her hand, there's shots fired.
Yes, Your Honor.
9 shots being fired, and she is not one of the 9 shooters. And so she doesn't know where these shots are being fired. The officers are running out of the garage, and she's firing behind them.
Right, but she's firing at somebody on the ground. She's not firing at where the shots were coming from. And the question is it an immediate threat? You look at Ailman, it says there was a threat, but it's not an immediate threat.
So it's interesting, to think about this. Do you look at it as if Mr. Shelton was who the officer
Belton.
Lovers
Belton.
thought it was?
I'm sorry, Belton? Yeah,
I
sorry.
apologize.
Go ahead.
No disrespect.
No, so go ahead. I'm sorry.
But do we look at it as if it was excessive force, from the perspective of whether it was not really Belton, but who Officer Loveridge thought it was? Or do we factor in that it's a police officer who was shot mistakenly? That, I don't really know, to be honest with you. I mean, those aren't necessarily the same questions, and that kind of
Right.
gets to my point is,
Yeah.
what right are we talking about?
And of course, it's not even excessive force, it's lethal force. We have these cases of lethal force.
We call lethal is a
Yeah,
kind of
version,
excessive.
certainly. But anyway, I'm well over my time.
You've helped us. Thank you very
All
much.
right, I appreciate it. Thank y'all.
Hear back from Mr. Bader.
Thank you. Three points I want to discuss with my remaining time, and the first gets to Judge Niemeyer's question about whether there is a factual dispute. Well, what the contention that the district court recited was the plaintiff's contention that she could see he was an officer, and to Judge Niemeyer's point, then you're effectively talking about murder.
That's, I mean, that, maybe you're talking about murder. I mean, if and I get the point, maybe that's an unreasonable look at the facts, but, I mean, would you not, I mean, maybe it's murder, but maybe it's mistaken manslaughter, maybe, I don't know, but if, would you agree with this, that if she could, if Officer Loveridge, you could tell it was an officer, that would be an unreasonable act to shoot at the officer?
I would agree then that that would be a question of law for the court. And I,
So just, maybe.
well, yes. I mean, to your point, sure, if a fact finder says you're deliberately shooting at another officer, and that would be a constitutional seizure, then you could.
I guess it's deliberately shooting an officer. I hadn't really thought that completely through, whether it's deliberately with malice to kill or whether you should have recognized it's an officer. Maybe you don't have quite the intent in the heat of the moment, but you should have. Look, I'm not so much interested. I mean, I think that's an interesting question. I don't know. The district court seems to have said there's a question of fact about reasonableness. Judge Niemeyer's question suggests maybe, and Rambert suggests that you can have a situation where what you say is a question of fact really, well, it says it may not, questions may not be material. So that's a different point.
I guess I don't want to get bogged down in this, but let me just, this is how I've synthesized this case, at least in my own mind.
Yeah.
If the parties there's different evidentiary disputes as to what happened. Okay, so that Witt versus West Virginia State Police, the plaintiff's evidence is they took me to the ground, they were the aggressors, they hit me with the gun. The officer's evidence is the plaintiff was the aggressor, he was accidentally hit with the flashlight. You can't resolve reasonableness with those kind of factual disputes. Here, there's no dispute about the facts. It's all on video. The other evidence about them not knowing each other, covering up the jacket, that's all undisputed. So the question really becomes, well, how was her reaction to him, which is really, should she have identified him as an officer, which I would argue should I have identified this person as mentally ill, it's this, you're in the same ballpark. So I still think the case can be resolved that way. But
I think the factual discussion is a very difficult one. And I understand the district court's conclusion on that. It's my biggest problem is that I can't. Yates quotes. This is really my biggest question that I have to answer. Yates says the Fourth Amendment bars police officers from using excessive force to effectuate a seizure. And she was not in the process of effectuating a seizure on Belton. It was a mistake. She was trying to engage in what all the officers were trying to do is to seize McConaughey. And so the question is, the legal question is, can you use the seizure of McConaughey as a constitutional basis to give Belton a constitutional right? And the answer to that question, I'm just not sure of.
And I don't know the answer to that question either, Your Honor, but I think that is the second issue I wanted to comment on, but really it teases out the third issue, which is the clearly established right, because this circuit has not said that officers involved in friendly fire, chaotic situations like this would have a clearly established right to be free from a mistaken shooting by one of their colleagues. And that really is what this case boils down to. It was a mistake. But what this court has said time and time again is that...
And you didn't argue anything about clearly established right below, correct?
No, we certainly did.
Okay, go
We
ahead.
certainly did. So we would ask that this court reverse summary judgment, find that Officer Loveridge is entitled to qualified immunity. Thank you.
I'm fine, but whatever y'all want to do.
We'll come down and greet counsel and proceed on to the last case. All right, the next case we're going to hear is Washington versus Pellegrini. You can take your time, but Mrs. Spence, we'll hear from you whenever you're ready.
Good morning, and may it please the court, Renee Spence for plaintiff appellant Gary Washington. In 1986 and 1987, defendants set about framing Mr. Washington for a crime he did not commit, a murder for which a court has found him factually innocent. The defendants coerced witnesses into fabricating inculpatory evidence against Mr. Washington. They suppressed evidence that would have gutted the state's case, and they used the fabricated evidence to deprive Mr. Washington of his liberty for over 30 years. At summary judgment, Mr. Washington has presented significant evidence of the defendant's misconduct. And the question before this court is whether Mr. Washington is entitled to a trial on these claims. The district court improperly granted summary judgment, and this court should reverse for two reasons. First, the district court improperly applied collateral estoppel, which led to the erroneous dismissal of Mr. Washington's claims. And second, The summary judgment record, when properly construed, demonstrates that there are genuine material disputes of fact as to all of Mr. Washington's claims, including his suppression and fabrication due process theories. A trial is warranted. As to collateral estoppel, there are 4 grounds, any of which the court can rely on to justify reversal. First, the Maryland courts would not have barred Mr. Washington from relitigating the issue of Mr. Robinson's coercion.
Was in the proceedings for the writ of actual innocence, was there a question about the findings from the earlier post-conviction proceeding where the court said he was not credible? Was any issue preclusion raised in the writ of actual innocence proceeding?
Yes, the state actually argued that Judge Peters was barred from reevaluating this issue because of Judge Schweit's 1999 order. And what Judge Biddle does in the post-conviction attorney, in 2 of the briefs that are part of the record, and they are located at JA 3763 through 3778, 3747 through 3761, is he says collateral estoppel does not apply. And that makes sense because of the way that the statutory schemes in Maryland are set up.
I didn't see any finding by the court that addressed it. I think they mentioned it briefly and then never addressed it. And they also never declared innocence. They did just, all they did is they said there's a possibility of a different result. They didn't resolve that and granted a new trial. So the question is, I'd be interested in hearing why Judge Schweit's order, which is post-conviction, he looked the witnesses in the face, he heard their testimony, and made a conclusion and entered a final order denying post-conviction relief, and that was appealed and affirmed. Now, that was a final order, wasn't it?
It's not a final order.
Why not?
Because the conviction has been vacated.
No, it wasn't. It's a collateral proceeding. It was a civil proceeding, post-conviction relief.
Yes.
And that's a separate proceeding, and it had a final judgment, and you have to appeal final judgments, that's all.
That's correct. You have to appeal final judgments. However, the effect of Judge Peters granting a motion for a new trial vacated the conviction, and therefore the post-judgment rulings that are tethered to that conviction lose preclusive effect. And multiple courts have found this.
Yes, that's what, go ahead. I want to hear the courts you're talking about that have addressed that in a, what authority is
in a
there?
Post-conviction proceeding. There is no Maryland state authority on this, as you see from the briefs, but you can look at Seekers v. Alex, which is an Eastern District of Michigan case, Glenn v. City of Hammond, Donald v. Outlaw. These are all cases that...
District court cases?
Yes, they are district court cases, and they are all cases where the court looked at the collateral proceedings, the post-conviction, and in some of those cases, there are multiple post-conviction proceedings where there are denials, and the appellate court affirms them, and even...
but that doesn't affect whether the Judge Schweit's order was final. Final, under almost every definition, is when there's nothing further to be done in that proceeding, and an appeal can be taken. An appeal was taken and it was affirmed. So what he did, sure, if he was going to grant relief, it would affect the criminal judgment, but it was a collateral civil proceeding and it was appealable, and there was nothing more to be done. He denied relief, and the Court of Special Appeals back then affirmed. Now, the question is, are we just going to, it seems to me that you want to just disregard that whole proceeding as if it didn't occur. As it turns out, as evidence comes out later years, maybe he was wrong, but maybe not. But quite apart from it, he did make a finding of fact. He took testimony, he heard the witnesses, and as you know, credibility questions like that are really things that the trial courts we defer to.
Right. Well, Judge Peters, while he did not rule on the question of collateral estoppel in the
He made a finding that they were not credible.
No, Judge Peters, in the writ of
Oh,
actual,
Peters,
yes,
you're
in,
talking Peters.
yes,
I was talking
he did
about
not
Schweiker.
rule, yes, he did not rule on the collateral estoppel issue, but what he does is he goes ahead and makes the credibility finding for Otis Robinson.
No,
He
he
is
doesn't.
required to do it. If you
But
look
he
at Jackson v.
didn't. He said there it raises questions of fact.
So in Judge Peters' decision, he cites to Jackson v. State, and Jackson v. State discusses at length what is required for a trial judge when granting a motion, granting a new
But
trial.
He didn't do it. All you have to do is read what he did. He said it created the possibility of a different result. And so he then granted a new trial.
But in order to create a possibility of a different result, which in a criminal case would be the not guilty or a mistrial, but a not guilty, Judge Peters had to assess the trustworthiness of the newly discovered evidence. Jackson v. State is very clear that newly discovered evidence, particularly when it comes...
These are all generalities. Tell me what he did.
What he did is he heard from Otis Robinson, and Otis Robinson gave substantially the same testimony that was in front of Judge...
Did he make a credibility finding?
He had to make a credibility finding. If he...
Did he make one?
Yes.
Where?
When he grants it, he has to make a credibility finding. That is the
I'd like you to
requirement.
point out in the record.
It does not use the word credibility, but the recantation is
There
not.
couldn't be the possibility of a different result unless the court believed the recantation.
Correct, because he is also required to consider.
Because
the
what other evidence
circumstances.
did they have at the trial in the first place against Mr. Washington? Only the testimony.
Absolutely.
of-
This was a pure eyewitness case.
So is that,
They
that's
had nothing else.
Correct.
Just like I was going.
No, that's all. Go ahead.
So I'm wondering about that. I mean, it seems at least theoretically, you could say in 2018, look, we got a bunch of versions of the testimony, for a period of time, and then we got a bunch of versions of a completely contradictory testimony later. If any jury had a witness who had said two different things, for as consistently as this witness did, then there's no way you could expect that to, a jury to believe one or the other. So in theory, I can see that you could say there's a reasonable probability of a different result without saying I believe the subsequent version of the testimony. But there was an issue you mentioned earlier that I wanted to explore with you. I didn't see a finding of actual innocence, but I think the writ at least contemplates actual innocence. So what do we do if there was never something that said actual? Because if there was a finding of actual innocence, that would seem to say I'm believing the later testimony. But
There is a later finding of actual innocence that we cite to in the reply.
There's-
There is a later finding of actual innocence that we cite to in the reply in a 2024 proceeding with Mr. Washington that did not happen. The finding of actual innocence did not happen at the writ of actual innocence proceeding. But that, when I am referring to that finding, I'm
it
referring
happened
to
when?
in 2024. It's cited in the reply, and we can supplement it with the
By
actual
what
opinion.
court?
By the Office of Administrative Hearings under the Maryland Walter Lomax Act.
Is that the one
He
by
was-
clear and convincing evidence?
Yes, it's a clear and convincing evidence standard. And so with,
Just to get
Is it
back,
in your
just to be
reply? I'm sorry.
clear, what Judge Peters found, he says, after the court went through this, the court clearly did not make the final assessment. What the court said is the court is left with the inescapable conclusion that multiple recantations of the uncorroborated testimony by the sole eyewitness in petitioner's case have created a substantial possibility of a different result. And the court then ordered a new trial.
Jackson v. State discusses merely impeaching evidence and impeaching
Just take
evidence.
these
And so
words. Can you take what he wrote?
yes, the
And the
recantation,
statute says he can order a new trial. That's part of the relief.
not on just the recantation. The full recantation is about the coercion. But even if the court is not persuaded as to the issue of whether these Judge Schrait's orders should have preclusive effect, there is a question of equities. Collateral estoppel is an equitable doctrine, even when the elements are met, which we discussed in the brief that the elements have not been met here. But to bind Mr. Washington to false testimony, particularly and to bind him to a 1999 order that did not have the full picture, that Judge
Binding him,
Peters.
What we're doing is we're accusing the prosecution and the officers of misconduct and in fabricating and coercing evidence and creating a murder conviction. And the record is pretty thin on that when you go back and read back then. I've read all the records, the statements, the testimonies, and I didn't sense that the officers were pushing everybody around. But forget that. We get to a point where there is a recantation 10 years later, pursuant to an investigation. The investigator comes and talks to this guy, and he recants. So they now file a petition for post-conviction relief. And the judge then hears everybody and says, I don't believe in the recantations. There was enough evidence there, and there's no evidence, and denied relief. Now, that's back there. The question is, at that point in time, do we have evidence that the officers were acting inappropriately? So then you come to the actual innocence hearing, and the actual innocence hearing, Judge Peters hears the same type of evidence, and he says, well, this raises enough of a possibility that the jury has to decide the issue. If he believed the recantation, he could accept it and declared actual innocence. He refused to declare actual innocence. He sent him to a trial for determining guilt or innocence. And that, of course, we know never happened because the state then processed.
That's exactly right. He sent him to a trial to have a jury determine the credibility of Otis Robinson, which is what the district court is barring Mr. Washington
No, I'm
from
talking about
doing.
the actual innocence.
Yes, Judge Peters sent Mr. Washington back to trial with no evidentiary restrictions such that that evidence could
I
be presented
understand, but
anew.
Peter's decision is not on trial here. What's on trial is Judge Schwait's judgment. And Judge Schwait actually took evidence and allowed all the parties to make the arguments they wanted. The recantations were on the table, and he made some conclusions. Now, we're not even talking about whether that is absolutely correct, because maybe evidence over the years comes out, but what we're talking about is whether the prosecutors or the officers prosecuted this case appropriately, whether they had probable cause to proceed, and whether they had enough evidence to proceed. And we're talking about a serious tort.
And what Maryland courts say is that when you have these two rulings, and it is unfair, right? The equities are favoring Mr. Washington because it's unfair to bind him to a ruling that does not have a complete picture. What Judge Peters hears is testimony from multiple
It's not a question of binding
people.
him to a ruling. The question is, are the officers exposed? In other words, the officers were told that they did not act improperly, that they had the evidence of the witness, two witnesses, actually one disappeared, so to speak, but of Robinson. And their notes were saying, well, you know, he said he saw what happened, but he won't tell us. So the officers put that in there. And then they said, well, we really ought to find out who it is. And he comes back, and then he identifies Washington. Washington, of course, I think you make a pretty persuasive case that it was Thomas or whoever did that. But he was part of the group there, and sure, there could be mistakes. But we're talking about malicious prosecution and pursuing lawsuits inappropriately. And the question is, now you have a state judge makes findings of fact that he looks these people in the eye, hears the testimony, and he makes a factual conclusion that the recantations were incredible. And I don't know why that doesn't get some weight. That's a pretty serious thing.
Yes, and vacating the conviction is a very serious thing. And what the defendants must explain is why collateral estoppel should apply when Maryland courts.
Why was Mr. Washington awarded $3 million, and by whom?
based on the finding of factual innocence, that he was erroneously convicted, the statutory compensation, and it was in part based on that evidence of Otis Robinson. And so what the defendants are not able to answer is why the defendant should get the benefit of their misconduct, and also where Maryland courts allow this inconsistency to arise based on the structure of the uniform.
What inconsistency?
The difference between the post-conviction, the 1999 order, and the 2018 order.
Yeah, your point there is that the Maryland law seems
Allows
to
this.
let someone do a do-over.
Yes,
I mean,
because-
maybe it's a different, the legal outcome is different, but the underlying claim is the same. And your point, I think there is, it'd be weird if Maryland lets you have a do-over, that's my word.
Well,
And-
Maryland, I'm sorry, yes.
No. And, you know, for us to kind of, you know, let the prior holding have preclusive effect. I mean, Justin makes some good points. I mean, that, you know, the actual statements in 2008 are kind of different statements. So, I mean, look, this is kind of tough.
Could I ask you, I know where the red light's gone, but obviously we need to, he was awarded $3 million and benefits and a lot of things. That's a good success. Of course, he lost 30 years, which is a terrible thing. Is there a collateral source rule? In other words, has he been fully compensated for his loss now?
For under the state statutory regime, there is an algorithm by which compensation is calculated, but it would be it's our position that he has not been fully compensated because
He got the median income in Maryland on a daily basis awarded to him. And he got benefits, and he got his medical care, and he got any other damage that they could think of, which added up to roughly $3 million. My question is, what other damage would you be asking?
it's not just money, it's accountability, which is
Well,
what the, it's,
I'm asking for damage. Are you asking for any more damages?
yes, we are asking for more damages.
What damages?
It would be monetary damages, but there is also a public accounting for what happened to Mr. Washington.
Stick with my question. I'm asking what other damages, and you say there are other damages, and I'm asking you what?
For intentional infliction of emotional
Yes,
distress?
for
I
intentional,
think
yes,
that's-
the intentional infliction of emotional distress is part of is one of the bases for the damage.
Wouldn't you also, I mean, I assume I don't know if punitive damages are recoverable in those claims. I mean, I would think you would say some intangible damages beyond what are available by the statute. You know, a statute can provide certain remedy. I don't know that statutory calculations are the same as tort law. I mean, there may be an offset. It may be that sort of thing. But anyway, that's not really before us right
Right.
now.
As it
And
relates
that's
to-
for the court to maybe, if there was a basis to dismiss because there's no recoverable damages, that'd be one thing. Right now, it's whether you get, you know, you're kind of stopped by virtue of the issue preclusion, right?
Correct, and you're right as to the
Yeah,
punitive
actually,
damages.
that's the narrow issue before us. I mean, we've gone on a lot of things, but the narrow issue is whether Judge Gallagher's reliance on collateral estoppel was appropriate.
Right, where the district court was required to do what Maryland courts would do.
Okay.
Thank you, Your
Thank you.
Honors.
I think you have some rebuttal coming back.
Thank you.
Mr. Redmond?
May it please the court. I'm Michael Redmond on behalf of appellees Officer Pellegrini, Officer Rickware, and the estate of Officer Feltek. We are here today not because Mr. Washington was convicted of murder in 1987, nor are we here today because Mr. Washington was able to get that conviction vacated in 2018. We are here today because in 1999, Mr. Washington filed a separate civil suit in a Maryland state court where he alleged that the appellee officers violated his constitutional rights by fabricating evidence and coercing Otis Robinson into testifying as to that fabrication. In 1999, after a full evidentiary hearing, the result of that civil suit was that the fact finder, Judge Alan L. Schwait, found that the evidence presented was insufficient to support those allegations by a preponderance. Judge Schwait's factual finding was affirmed on direct appeal by a 3-judge panel of the Appellate Court of Maryland, and that 1999 factual finding has never been vacated, overruled, or called into question in any way. Yet 20 years later,
It was called into question by what you were just getting ready to talk about, the decision 20 years later.
okay, then 20 years later in 2019, Mr. Washington filed a second civil suit, this time in federal court, making the exact same factual allegations of constitutional violations against the appellee officers. Washington asked the district court to allow a jury.
Wait, then you're not talking about it. It was called into question by the the later finding that was by the state court. Yeah, that was inconsistent with the prior finding, and so it
I'll
applies.
jump right into that, Your Honor.
You just can't say that doesn't exist,
Well, I'm.
or pretend like it doesn't exist. So go ahead
I
and
certainly do not mean
let's
to
act
pretend
like it
any such thing,
exists.
Your Honor. My plan is to tell you exactly why it does not call it into question. It is not inconsistent with it. Washington's first argument is that the 2018 order from Judge Peters that got him out of prison contradicts or conflicts with Judge Schwait's 1999 judgment, but that is simply not true. In 1999, Washington needed to prove by a preponderance of the evidence that the police officers coerced Robinson and fabricated the evidence against Washington, that they violated his constitutional rights, and he failed. And then 10 years later, in 2009, the Maryland General Assembly passed a new law, Section 8301, that made it a whole lot easier to get a conviction overturned because instead of having to prove a constitutional violation, all it requires is, quote, newly discovered evidence that, quote, creates a substantial or significant possibility that the results may have been different, end quote, if the jury had the newly discovered.
Does it require actual innocence?
No, it does not require actual innocence. It does require that, I believe there's a requirement that the evidence speak to innocence in some way, but it doesn't require a finding of actual innocence in order to get into it. It merely requires that there is.
And the evidence here does speak to actual innocence because the evidence here is the recantation of the sole witness at trial against Mr. Washington.
Yes, so that is an entirely different question of whether or not he is innocent is not what was determined in 1999 by Judge Schwait. That was whether or not.
Let's assume, I think that is fair, that the question is different. You know, they're related, right? I mean, they're certainly related. That they go to the testimony and the recantation. It probably is accurate to say it's not the exact same finding. You must have thought it was pretty close if you tried to, argue issue preclusion in 2018. Not you, may have been you, right. but apparently there was an attempt to argue that by the state at that point. But that's really beside the point. Here's, I guess, what I want to. There's a lot of cases that say orders pre-conviction are, essentially rendered invalid by a subsequent, motion for a new trial. There's some district court cases that your colleague cited that say post-conviction orders, are also, because they're so connected with the conviction. Do you have a case in a situation like this that helps you, a post-conviction relief finding where there was a later grant of a new trial, where issue preclusion was permitted?
Your Honor, we do not have a case directly on point. This is a question.
That's what I thought. That's fine.
A question of first impression.
Can I ask you
We should send it back to the Maryland Supreme Court?
That would be certainly a perfectly reasonable course of action, but I don't think we need to because Maryland State, sorry.
I have a follow-up. So if you're right that issue is binding on future litigation of that same issue in other settings, what if you had retried, what if the state had retried Mr. Washington, and Mr. Robinson gets up and is called to say, "I never said that"? Would that be would the state be able to get up and say, "Hey, you can't do that. This issue's already been decided"?
I don't think so because there are different considerations with a criminal trial and constitutional rights about that. But more than that, it's a different question, a different standard of what there has to be proven when there.
This is not a legal issue. This is a factual finding, whether Mr. Robinson was credible. You're saying that fact has been determined, and so it can't be relitigated. If he was retried again, Mr. Robinson's credibility would be at issue. And why would you say issue preclusion only stops in a tort case or a 1983 case and not in the criminal case?
I think the real issue that is precluded is whether or not the officers coerced Mr. Robinson and.
That's not maybe that's your argument. I thought it was more narrow. I thought it was a factual. I thought what the judge I forget the 09 judge Schway. Yes. I thought that what you were saying was collaterally decided that is a stop from being relitigated is that he was deemed to be incredible in his testimony.
The determination that he as the fact finder made was that yes, this testimony is incredible because of the impeaching prior statements and things like that. However, the actual holding of that case, the actual factual finding was that there had been no constitutional violation, that they had not coerced or fabricated these things, and these are the exact same allegations that were found and are not found to be supportable by that fact finder. Those are exactly the same things.
So your argument is not that what's precluded is the limited factual finding of incredible testimony. It's the legal implications of that on constitutional violations? The
actual finding of Judge Schwait of the Circuit Court for Maryland was that there was that Mr. Washington had not met his burden, the preponderance by preponderance that he had not proved that there was any constitutional violation, that there was any coercion or any fabrication. That is the actual factual finding. Why he found that is because a subsidiary factual finding that I don't find is credible. Both should be precluded.
I'm going to switch gears a little bit. Your colleague makes the point, and you make it too, that Maryland passed a statute permitting this writ of actual innocence. And it may be a lower bar. May be a different bar. I'm not really characterizing it. But it just strikes me as strange that Maryland would permit the same sort of claim, same factual, basis for a claim, that it seems like it's undeniably permissible under Maryland law. Mr. Washington wins, gets a new trial, and that 2009 case would bar it. It just, this is such a weird case. It's not like any that we found. You said it was kind of a new animal, so to speak. But it seems remarkable that Maryland would grant him a new trial, and then an earlier finding inconsistent, to some extent with that decision, would somehow bar the civil claim?
Well, I think that it's important to note that the statute, the newly passed statute in 2009, set out that it just had a much lower bar, the substantial or significant possibility that the results may have been different bar, which Maryland courts have interpreted that as being less stringent than probable. That's McGee versus State, 449 MD at 510.
If he was by law incredible, you couldn't say there would be a substantial likelihood of a different result, could you?
Well, it's kind of a different determination, because what this is saying is not, you're not judging.
Answer that, Judge Quattlebaum's question.
I mean, how could
Possible.
Judge Peters say there was a substantial likelihood of a different result if he, I don't know if he's a he or she, didn't believe there was a question about whether or not Mr. Robinson was credible?
Because he wasn't making a credibility determination himself.
If he thought he was incredible, he couldn't have found that. I know he didn't say, I hereby find him credible, but how could he say there is a reasonable likelihood of a different result?
Possibility, he didn't say likelihood.
Right. It's not only a possibility, not a likelihood. It is, and there's also, it is really a.
Said it seems irrefutable that the outcome of appellant's trial hinged completely on the credibility of the 12-year-old Otis Robinson.
Yes, and it is a meta-determination, if you will. He is not making a credibility judgment of, yes, if it was completely outlandish, he could say, yes, that is not going to be, but there's a significant range in there where the 1999 Judge Schwait order, he was making the factual determination. I decide, is it enough to create a preponderance of the evidence? He decided, no, it wasn't.
How does your argument serve, isn't collateral estoppel an equitable doctrine? How does your argument and what you're trying to do here serve the purposes of equity and fairness? I'll change Judge Quattlebaum's word weird to fair. How is this fair?
Because when you're weighing the equity of imposing collateral estoppel, it cannot be just that we don't like the result that happened before. I
don't think that's what you're arguing.
I'm sorry, Your Honor, I didn't mean to mischaracterize that. But to weigh the equities here, you would have to weigh what Washington loses if we bind him to the fully adjudicated civil factual determination, namely getting a second bite at the apple, versus what the defendant officers lose, namely having to defend themselves 25 years after the first civil decision, after decades of forgetting, after evidence disappearing for decades, and even after one of the officers dying, Your Honor. I'm sorry, Your Honor. You have a question?
Go ahead.
No, I think that's, I mean, look, those are challenging things. That's why, when this happens, oftentimes there's not prosecutions, retrials. Sometimes it's because there's deemed innocent, sometimes because you can't prove the case due to witnesses being, either gone or unavailable or not having memory. I mean, I get, and you're certainly right that, defending the claim, may be difficult, but prosecuting the claim may be difficult. And, Mr. Washington was in jail for a long time, and the state of Maryland has declared him actually innocent. And, I didn't make the 1983 statute, but it's there. And so, I mean, there may be some, challenges to the officers. I think you're fair in characterizing them, but there's some equities on the other side.
And if
Ask you something.
yes, Your Honor.
This statute, the actual innocence statute, can have the functional tendency of overruling an earlier post-conviction relief claim. In other words, it is another form of post-conviction relief on a lower standard. And so if you have one post-conviction relief denied, and maybe that's because the higher standard was not satisfied, then you come under the statute and you have a lower conviction standard and you can get a new trial. What does that do to the first post-conviction determination?
It depends on the factual determinations that were made.
Legally, what's the effect?
Yes, and if those factual determinations are questions about reviewing the trial itself, of what happened there, then there's a much better argument that, collateral estoppel shouldn't apply in that situation because that has now actually been vacated in situations like that. But when it is a de novo determination, a new factual determination like we have here in the 1999 Schwait decision, that is because Maryland courts treat these things as separate civil cases, and they make it separate from the criminal case. It is its own separate civil case with separate civil factual determination. That is
That's basically analogous, to our habeas process and all post-conviction things. But Maryland comes along and passes a new statute, which has the effect of permitting the defendant to have a new trial, whereas I thought post-conviction relief was designed to do that.
It was different routes to different methods of getting the same relief, however, of getting a new trial.
Doesn't that raise some legal difficulties in what is the legal effect of the post-conviction relief determination when you are allowed to try it again under a lower standard in the innocence?
No, Your Honor, because in this instance, and obviously collateral estoppel is always a case-by-case basis. However, in this instance, you are not actually addressing the same question, just at a different standard. You are addressing two different questions. The first one, it was there coercion, was there fabrication, was there a constitutional violation? On the second one, Mr. Washington's lawyer in 2018 or 2016, when they were adjudicating the writ of actual innocence thing, they actively argued exactly what I'm arguing today. This is reproduced on page 25 of the appellee's briefs, and it's at Joint Appendix 3750. Unlike in the post-conviction proceedings, which require proof that the officer coerced Robinson to lie in court, all that is necessary here to grant relief is for this court to find Robinson's recantation is newly discovered evidence, regardless of the reason he wrongly or mistakenly or incorrectly or falsely identified defendant Washington as the shooter at trial. While a mere recantation by Robinson was insufficient to permit post-conviction relief previously, it's sufficient now pursuant to the writ of actual innocence. So it's...
And I hear you that it's a lower standard, and so they're not answering. Maybe that is a good response, or to the claim that the 2018 decision it overrules it. But regardless, Maryland has permitted that. The conviction is now gone, and I grant you, if you go through the elements of issue preclusion, I'm trying to figure out where there's not issue preclusion. And the only place I can see is maybe the validity of the judgment. And I grant you, it hasn't been specifically, overturned on appeal. It was affirmed. But does somehow a subsequent, grant of a new trial, just because of the relationship of that 2009 proceeding, does it make it invalid? That there's no cases that talk about this, and then I guess the second point would be, and I'll let you respond, is even if they're all satisfied technically, do we have an equitable situation like Judge Thacker was talking about, where just given the circumstances here, where Mr. Washington was granted a new trial, it would be inequitable to preclude him from putting on that evidence and at least making his case?
No, Your Honor. Sorry, let me address the first question first. That there is, because there's nothing that overrules or vacates the.
I agree.
But, okay, and
That doesn't necessarily mean it's still valid if the thing that it was connected to has been vacated.
And that's exactly the question, the connection. What is it that makes, in other contexts, a post-conviction relief sometimes be no longer valid? It is because you are directly reviewing, even if not on actual direct appeal review, you are often using the post-conviction relief avenue to directly review what was done at trial. And in situations like that, yes, it makes sense that disappears, that becomes invalid. When, however, you are making new factual determinations, when you are presenting evidence and you are in any other civil trial and trying to prove that by a preponderance of the evidence, that should be treated like any other civil trial and have issue collateral estoppel in exactly the same way. And that is a big part of the equity of it as well. It's not just, equity isn't just the court decides they would like it one way or another. It is a matter of what is fair as a process as a whole, and in the situation here there are undoubtedly balanced equities on both sides to be balanced, and if the trial court has made a determination of what is fair or not fair, and she said to weigh it at it would inevitably be more, it would unquestionably be a fuller and fairer opportunity to try this issue in 1999, only 10 years out, than it is now 35 years out.
Okay, we got that.
Okay. And with that, the appellate officers would ask this court to affirm.
Okay, thank you. Ms. Spence?
It is not that Maryland decided to make it a whole lot easier to get a conviction overturned. It was specifically designed, and the appellee's brief, the defendant's brief refers to Hawes v. State, which discusses the difference between the Uniform Post-Conviction Procedure Act and the writ of actual innocence. The writ of granting a new trial based on newly discovered evidence, as Jackson v. State talks about, is about serving the ends of justice. This is to make sure that they get it right, which is also what collateral estoppel is concerned about. That equitable consideration is about permitting relitigation, even when the elements are met, when there is a concern that there is going to be an inequitable administration of the laws. And that is what happens here. Yes, it is true that the defendants do not remember this, or the prosecutor doesn't remember each and every detail, but that is what happens when people are wrongfully convicted. It takes decades to unwind the misconduct. They should not get the benefit of this misconduct. When courts have looked at these types of cases and weighed the equities, as they did in Evans.
Didn't whatever the second court was, find that Robinson was the sole eyewitness to the crime and amounted to the state's entire case? That's why they couldn't retry it. They had no case. Didn't matter whether they forgot this, that, or the other, or didn't have documents. Their entire case, according to the later opinion, rested on, and according to the record, rested on Robinson. They had no case anymore.
They did not have a case anymore, but here, even the equities favor favor Mr. Washington be able to present it to the civil jury because it's a fuller record, but also where there, in Evans, in Gilliam, in Bermudez, which is another case, Your Honor, in the Second Circuit, where they found that on substantially the exact same facts. There's a habeas petition. Its appeal is affirmed. The post-conviction is denied. And then there comes along, on the same evidence, a granting of a new trial for newly discovered evidence that was previously rejected. And the court found that the...
Was the Second Circuit case, is it Bermudez?
Bermudez.
Was the basis of, how was that, remind me how that was, I think they decided that on equities, is that right?
They did ultimately decide it on the equities. They said, given the history of the case, which is very similar to Mr. Washington's case, where there is a finding of innocence, I believe the state conceded innocence at that point, that he should not be barred from relitigation. But even then, they didn't say that collateral estoppel would otherwise be a bar if not for the equities.
But there was a concession of innocence,
by the state.
and it was based on equity and not the absence of issue preclusion.
They never find that their issue preclusion should even apply. But it's similar to what this court did in Gilliam v. Seeley, where...
Gilliam's, I think Judge Thacker wrote that opinion, so, but my memory of that was that involved a ruling before the judgment.
That involved the reading of North Carolina, the North Carolina law with the fraud exception, but there is a footnote where it questions whether or not collateral estoppel should even apply in Section 1983 cases because it runs afoul of the thought process about accrual.
The issue in Gilliam was the ruling that for which issue preclusion was sought was a pre-conviction ruling. And so it's pretty established, I think, that all the judgments and orders leading up to a conviction are undone. Here we have a post-conviction order, and I understand your argument, but it is a different situation.
It is on different footing, but you can also look at Glenn v. City of Hammond, which speaks to Your Honor's concern about the fact that it's not directly reversed. Even in Glenn v. City of Hammond, the court finds that those post-conviction or the collateral attacks had not been directly reversed, but the conviction being vacated meant that those post-judgment rulings did not have preclusive effect. And Judge Peters did, like Judge Schwait, hear from Otis Robinson. He was able to assess that testimony in real time and have a fuller picture of what happened. In addition to hearing from Otis Robinson, he heard from two witnesses who identified an alternative suspect who had confessed multiple times. He learned that the appellee who is in this case, Thomas Pellegrini, was being currently sued for substantially the same misconduct of suppressing evidence and coercing a witness. And again, this collateral estoppel is not, Burkett talks about collateral estoppel is not concerned about the judgment. It is primarily concerned with the factual findings. And here, Mr. Washington should be permitted to present these facts to a civil jury because a Maryland court wanted him. Judge Peters said that he could.
Judge Schwait's decision was presented to Judge Peters.
Judge Peters was aware of, yes.
I mean, was it actually presented and argued to Judge Peters that he was bound by Judge Schwait?
That is what the state argued, that
They
Judge
argued
Peters,
that,
and Judge Peters reviewed it and said, I'm going to go ahead and make my decision because I'm allowed to make this decision because this is what Maryland empowers me to do, to put Mr. Washington in the position of a new trial where he is not, where it, as if the party, no trial had ever happened. And so the summary judgment record is rife with genuine disputes of fact that a jury must decide. And the defendant should not get the benefit of their misconduct by invoking a technicality to bar full and fair consideration of what happened to cause his wrongful conviction. The inequitable and erroneous application.
Red light on.
Oh, sorry. I saw the numbers keep going down. I'm
We
sorry.
don't give tickets, we first give warnings.
Thank you, Your Honor.
Very well. We'll come down, we'll adjourn for the day and come down and greet counsel.